All right, guess we can get started. Well, to kick off, my name is Maceo. You all may have seen me yesterday at the 2 sessions we did, but if you didn't, I go by the ERG Homegirl on LinkedIn. The ERGs take over my life in the best way possible. Today, like I said, are going to be doing a little bit of a trivia, which I'm excited for. Couple of disclaimers, because really this session, because it's around legal things, I have to say I am not a lawyer. However, 2 parts with that. One, everything that I'm talking about today, I've spoken to lawyers about. So it's not like I'm just saying it hypothetically. This is verified information. Sometimes in these sessions, people will ask follow-up questions. So I just want to prepare you. I'm going to tell you, if I actually don't know, you should consult a lawyer or your team's legal department ultimately, just because I like to speak on things that I know as a fact. So just be prepared. That just happens sometimes. Additionally, I guess I'll mention it here at this point. Your team at your company, you probably have a legal department, so you can also check with them. One interesting learning that I've had, and I mean, we're at a tech conference, so I'll say even when working in tech, is sometimes our legal department is very small. Sometimes be like a general counsel legal person. That means that they're not necessarily specialists in employment law. Now, I'm not dissing them in any way, but I'm saying they might not have knowledge on this conversation here. Even as I've spoken to different lawyers, that's why I said in plural, I've spoken to a number of different people, so they will gladly say, oh, this is out of my lane of expertise. So I would say, I'm bringing this up to say, in addition to flagging it with your company's legal counsel, your company might be interested in seeking outside counsel as well. That is a specialist in the things that we're going to be talking about today. Does that make sense? All right, now with this trivia, it is going to be interactive. We're going to be using a tool called Slido. So in a second, you're going to get the QR code to join. Now, I don't want you all to incriminate yourselves and necessarily say that your company is doing some of these things, although I know that it is very common at a lot of companies. So when we go to the Slido slide, you can use like a nickname. We're going to start with the easy question. This is the only one with the timer, actually. Yeah, so you have the answer. They've been around for some time. And for the people who were around yesterday, you would know they've been around since the 60s in particular, 1964, same year as the Civil Rights Act was passed is a good way to memorize it. Xerox was the first company with an ERG. Their first ERG was the Black Employee Caucus. Now they go by the National Black Employee Association. And basically, when you think about what was happening during that time, I don't want to just say chaos, but even with the Civil Rights Act or movement, a lot of people were passionate. And we talked yesterday about how when you bring different people into the workplace, now there's a new challenge of belonging that they face. From 1964 on, for the next 55-ish years, basically, a lot of different ERG communities were created. That's why I call it the ERG spread. So now it wasn't just the Black community. The second ERG was actually an Asian American ERG at Xerox, but from then there was also like Hispanic ERGs, a lot of women's ERGs in the 70s, a lot of LGBTQ ERGs in the 80s, so on and so forth. So while they still weren't widely popular, at the same time, you were starting to see more communities launch. Now, from there, something changed in 2020, and this is what I was going to go into earlier, but because, again, it was this time where people were passionate about the work, ERGs also, therefore, saw a spike, essentially, in engagement. I actually call it the ERG boom because in this time period between 2020 and early 2024, thousands of companies launched their ERG programs. And almost like seemingly overnight, like before these were really just grassroots communities, now there were things that were maybe heavily invested in, a lot of high expectations. And we talked yesterday about how the front end of most ERG programs were developed. So now we might have had new logos and names and things like that, but oftentimes the back end of the program did not experience that same development. And that also speaks a lot to what we're talking about today with the legal things. Because with some of these things, you might be like, well, how do we not know that before? It's not just the legal things. In so many ways, ERGs were not upgraded on the back end. And that's what I'm excited to dive into more. And that's why I call this period the ERG movement, because I'm really passionate about setting up ERGs for long-term success, which also means when it comes to compliance-related things that we also have to get set up for long-term success. Make sense so far? I'll also give some comfort with this topic here, because I will just say community is a thing that's like inherent to humans, but especially when things are happening in the world. people seek communities. And honestly, I'm not concerned really about the state of ERGs, even with current legislation. This presentation, fun fact, was made before the executive orders were put out. There was already legal things that needed to be discussed. Now, there are some other additional ones, but I think that they are factored into a lot of things that I already had, honestly. But we can have a discussion about executive orders at the end, assuming we have some time. Also, this is not to say that you need to do a complete overhaul overnight necessarily, but I do just want it on your radar, essentially, so that you can make a plan to address it. Okay? That's more or less what this slide here is saying. All right, now we get into the good stuff. An LGBTQ plus ERG, if they require their employees or require people as they join basically to disclose whether they identify with the community, or if they require someone to refer them into their ERG, what should be HR's best course of action? So stating that again, if the only way to join the ERG is to say, hey, I identify with this community, or for you to be invited by someone who's already in the community, what should be HR's best course of action? If any at all. Good stuff, 100%. I love to see it. Now, if you're curious on the context, why? I guess that this was the answer, but I'm not exactly sure why. One of the lawyers that I've already spoken to on these topics, her name is Tiffany Thomas. We launch ERGs and make it so that we're protecting the psychological safety of our members by only allowing people who identify with that community to join an ERG. So if you're not identifying, you cannot join an ERG.
Absolutely red light.
Wow, okay.
Absolutely red light.
That is
So here's the thing. Most folks know about the Supreme Court decisions of last year. And to boil all of those words down into something very short is that if an employer is offering something of benefit to one group that is not available to another group because the protected characteristic, and protected characteristic is race, ethnicity, gender, LGBTQ status, disability status, like fill in the blank. If you're offering something to one group that you're not offering to another because of their protected characteristic, that is illegal. I get the idea that folks want to have a safe space, right? But that's what your friends do. That's not what we're business for. And I would rather have an ERG that supports me and my background, that includes allies, than to not have an ERG at all.
Okay, so like I said, you could hear it from me. I was definitely saying this a lot last year, but I think it's more impactful when you hear it from an actual lawyer who's a specialist on this topic. Now, with that, I do see a lot of ERGs do this to this day. And that's why I bring it up. Now, this isn't the only thing that we'll talk about. There are some things that are maybe not saying, hey, if you don't identify, you can't join. That's like the most extreme, essentially. Let's see about some kind of adjacent scenarios. Oops, there we go. Okay, so let's just say that a company's Black ERG. Now, it's always been ally-free. They have a separate channel space, no allies, but they do have a public space where allies can join. Is there legal risk here? Look at us, we're doing good. The questions get harder, but so far, I'm proud of where the group is at right now. Yes, it can still be seen as discriminatory. Now, again, I'll talk about it a little bit in a second, but I do want you to hear from Tiffany on why this is a concern. I know a lot of listeners are probably thinking, we can technically have that secret space, and oftentimes it's like a private space that is still an ERG space, but they figure people don't know about it, it's fine by. So we have a private ERG space. Let's just say it's a Black ERG, we're calling it more the culture, right? And then we also have a public one. This is the one that employees typically know about when they join ERG. They think that they're joining just by being here, but let's say I'm not Black, I'm not gonna get invited to for the culture. What about that?
But it really depends on how your ERG is set up. For every company that you had ruling was about what an ERG can do and what an ERG can't do. And to the extent that you have the front-facing, what the real group is behind the scenes, I still wouldn't advise that. Because we have activists, politicians, folks who are trying to make a name of themselves, who are just trying to poke at DNI. And ERGs are low-hanging fruit. And so all you need is that one person who you think was down. All skin folk and kin folk, right? At the blow of a whistle on the group.
So again, I'm just hearing it from me, and I'm speaking also from experience, not just working with a lot of companies, but being a prior ERG leader. I've been part of those channels, the ones that are like the secret ERG channels versus the public ones. They exist at large still today. We'll talk about one more adjacent scenario. Curious what you all think on this one. So let's just say, going back to the LGBTQ ERG, technically the group is private, but anyone can join. But it is private just because they don't want to out their members, essentially, by having just this public space that anyone can peek in on. Is that a concern? Got a little bit of some different answers with this one, which means I'm telling you, the questions do get progressively harder and harder. However, the one with the most amount of answers was the correct one, though. Even that could be seen as discriminatory. Again, this last piece, I'll let you hear from Tiffany once more. Yes.
I listened to the recording that you shared, specifically because of the Supreme Court's ruling last year.
Really just because when it comes to discrimination in the workplace, oftentimes right now we feel like that's relevant to minorities only. However, even for the majority group, we can't say that they can get something or that just the minorities can get something and the majority group can't. And in the context of ERGs, where one could argue, hey, by being part of this space, I have access to networking opportunities, mentorship opportunities, maybe even working with an executive sponsor. Now, by them not being allowed to participate based on their identity and their protected characteristics, that is what people are actually suing for.
So this has to do with equity, right? And so is it saying that equity could be legal?
That's an interesting take, which I guess to that point.
And I don't want to be sure, but if that's almost what it's saying.
Yeah.
It's the picture of the race, it's a picture of the wall with the boxes,
Yeah.
the stairs, and people need these household accommodations in disability.
Yes, comma, I'm not a lawyer, so consult with a lawyer. However, I will just say realistically, and while this has always been illegal, this here, even though it's been done, it was low risk for a long time. And the reason why is because the groups were so informal and oftentimes not even necessarily company sponsored. A lot of times, a lot of the budgets came around the 2020 era and the expectations. So when it became a company group, that is essentially when it changed the perspective. And now like I said, it was always illegal, but there have been a rise in cases around this where people are suing, saying that they don't have access to certain benefits based on their characteristics. All right, we'll hear from Tiffany and what she had to say on this. But let's just say that the private channel, let's use the LGBTQ community, for instance, where maybe someone's not out, and we just technically, let's say that anyone could join, but it's private. So we're still behind you, but we're gonna let you join and you say it. What is that? Should we be concerned?
I would be concerned because there are people who are working overtime to roll back the rights of LGBTQ people. And that means infiltrating a group. Like, folks have too much time on their hands. And especially with that community, if you don't want to see out to people who aren't supported. But this is the world that, we live in. And if you have true allies in that group, they'll give you your space. That you talk about a specific topic and they're truly an ally, unless they're oblivious, which a lot of allies are, especially those who give themselves the destination. But your allies should give you that space. And in that community, having privacy is so important. But I think you just have to protect those employees. Don't have folks outing themselves. I would ask for some team agreements at every meeting. That everyone, this is not a place to joke about whether someone is out or should be out or anything, and set those two agreements. But it's very hard to have a private space because, again, the law is moving into an area where you can't have anything for yourself because I'm entitled to that. I need access to me. I know I'm not of this treaty. I don't care anything about this treaty, which can keep me out of it. Because if you keep me out of it, I need an excuse to sue. And we know the U.S. is a historically litigious society, and it doesn't take much for someone to file a lawsuit.
So, again, not coming from me, from an actual lawyer. And as mentioned, people, they're oftentimes just looking for a reason. And this was recorded, by the way, in November of last year. So before, like I said, even the things that are happening now have been happening. And this was already the case. So putting that on the radar, we're going to keep talking on this topic, really, when it comes to all things that might be viewed as discriminatory. Next question here. Religious ERG in particular, what is the consideration that we should have? Also, I'll just mention, before I forget the thought, the reason why those first 3 questions I specifically said Black community and the LGBTQ community is because those are the 2 top communities that have private spaces within the ERG space. I'll have sometimes maybe a disability ERG, rarely, but sometimes an API ERG or a Hispanic ERG, but more than any other community is LGBTQ community and the Black ERG. Those 2, always where I have to have this conversation. Most of us did get it correct. The company must approve all religious ERGs if they approve one. This is so important to note. This also applies to those protected characteristics. Right now, I've seen a rise in like Jewish ERGs and Muslim ERGs. Some companies have already had a Christian ERG for some time. But again, once you allow one, you cannot say no to the rest. Also, that doesn't just mean majority religious ERGs. That means that if someone wanted a pagan ERG, if someone wanted whatever ERG, you can't say no because you said yes to one, essentially. And that's why religion in the workplace, it gets touchy, honestly. That's up to every company on if they want to broach that. However, I will say personally, I have seen when it comes to the Jewish community in particular, I've seen it approached from a cultural lens where you could say, you could have this community. Even me, I live in Detroit, Michigan. A lot of folks don't know, but there's a very large Jewish community. I've seen it firsthand, like there's a cultural aspect to the community. So a lot of companies, that's how they have the workaround for that community in particular. A lot of API ERGs maybe might touch, or Middle Eastern ERGs might touch on like the Muslim topics sometimes. But in general, if you allow one, you allow them all. Also, like I said, I like to come to these with proof. So just a case worth noting, if you just want something to reference in case this ever comes up within your organization, note the year 2005. That means this is something that's been in existence, but a lot of people just don't know. This employee sued or attempted to sue General Motors because they would not allow a Christian ERG to exist. What do we think he won with that lawsuit? Just based off of what I just said.
It depends on if they approve another.
Excellent. And they did not. They had it stated explicitly that that there are no religious ERGs in the company. Therefore, he lost. But without that being documented, they would have not been protected, which to that point, that also means that your documentation is really the thing that can make or break when it comes to a lot of these conversations or unfortunately with lawsuits. So you want to have it stated explicitly. What I recommend is saying what ERGs are and what ERGs are not, what is out of scope and what qualifies as an ERG, having that documented in your ERG's documentation. All right, next question. Of the following, ERG deniers will be legally problematic. All right, let's see what we've got. Good. I like it. I like it. I did technically give it away, but I'll give it to y'all. You all just knew that already. But that would mean that a men's ERG is on the table if you have a women's ERG. And that is the reality. Because again, ERGs, although we've talked about them and in so many companies' documentation, it states that ERGs are for underrepresented folks. Remove that like immediately. Because it's not just for underrepresented folks. Otherwise, people could say, I'm being denied this benefit based on my identity, which also means that a Caucasian ERG, also not off the table. Also, I've seen them at companies, just in case you're wondering. And a men's ERG, I've seen them both. So, I've seen them. That being said, just something to know. Now, I'm not saying that you have to necessarily be proactive and start one. You can still wait for employee interest to say, hey, this is what we want. But when they do ask, you just couldn't say no. All right, going to the next one. A company's API ERG only allows women to run for leadership positions in their ERG. Is there a legal issue? Doesn't matter. It's a volunteer program.
Can you just give the acronym API?
Oh, yes. Asian Pacific Islander.
Okay, that's what I thought.
Yep.
We just work for our company.
No worries. Oh, yeah, I guess that makes sense. I never thought about that, but yes. Asian and Pacific Islander ERG. If that ERG only allowed women, because they just really were passionate about Asian and Pacific Islander women. Good stuff, good answers. Now, what if, yes?
Can I flip so if it's a women's ERG, I'm gonna say yes.
That's exactly what I was gonna say.
Biased, but does that make sense?
That's exactly what I was gonna say. I was gonna say, what if it's there instead of only allows women, but only allows people that are Asian or Pacific Islander? Same answer still, which means anyone could be an ERG leader of any ERG.
So if you open it up, you can't say.
You cannot say that we have priority towards those who identify with this community. And that is the reality. Now, again, to be fair, it always was the reality, but especially in like right now, which we'll talk about with the executive order piece, I see a question that's come through on that. Just know right now people feel especially passionate about making those cases and suing for these things. So that's why I bring it up. Now, before I say this part, let me double check. Okay, yeah, we have a couple more, so I won't say that part. But yeah, long story short, I hate to have all these bummer sessions where I'm like, hey, by the way, things are in disarray. Okay, this one here, a working parents ERG, and actually, just for more explicitness in this question, let's replace it with a Hispanic ERG. That is the smallest in the company. If that ERG consistently receives less funding, but it's also because they are the smallest in the company, is there a legal risk? In that majority at the bottom is correct. Disparate treatment, which more or less, that would mean someone is saying, hey, because of situations out of my control, so in this case, we're Hispanic, but we also have the least amount of employees, so you can't really penalize us in our budget just because we have the least amount of employees based on our identities and stuff out of our control. There's another term that I would recommend looking up. There's disparate treatment and disparate impact. Just stuff that we don't have time to go into today. These are real things that are happening, by the way. That's why I'm bringing it up in these conversations. Don't worry, questions still get harder, but we'll get there. So let's just say, and we had this question yesterday, so if you were here, I already gave this answer. But if you require members to state if they're an ally or not as they join your ERG, is that a problem? All right. Yes, it can violate privacy laws and create potential discrimination risks. Honestly, and I don't think that we can touch on it too much beyond this, and honestly, I guess I have a couple of slides on this, but just know ERG leaders should not be handling personal, private, protected information. And even then, when you have members identify themselves, let's just say, for instance, if it was an LGBTQ group, and you had the member say, hey, do you identify? You're going to be allowed regardless, but we just want to know. The thing is, even if someone were to state no, technically, they are identifying their personal, private, protected information, even though it's the majority group that they're identifying with. So with that, again, ERG leaders should not be handling that data for what we'll talk about in a second, and the discrimination risk that can come up with it. So just to kind of overview, we'll do a little bit of terminology here, but one, workplace coercion. Why is this relevant when it comes to ERGs in particular? And one, just to define it, when people feel pressured to join, participate. I will just say that this applies broadly when it comes to ERGs. So if people feel that they're being coerced to participate in programs against their wills, this could be an issue. Also, I will say some tips. So things that we can do to avoid that. Make sure that it states explicitly in our documentation that participating in ERGs is voluntary. Explicitly, that word should be in there. Also, although ERG executive sponsors, leaders, they can encourage participating, it should not be an aggressive encouragement to participate. So that's why you all might say, what does that look like? That's why I'm saying in your documentation, what we talked about yesterday, you need to have that baked out for your company in particular. I wish I could give you all language for every company, but I'm telling you, I work with a lot of companies on their language, and they all land somewhere different. Yes.
So if our CEO has his weekly update, at the end of the week, this is what I did this week, this is what we got coming up, check out this employee group that's having this event.
It's
This
no.
is coming up, we're doing a trivia game night, join us. Would that be seen as pressure because it's coming from the CEO?
two-part answer to this. First one, I'm not a lawyer, but I will say, working with a lot of companies who do ask their counsel or do seek external counsel, that has been okay, but it comes down to the language that's being used from the CEO. So if it's saying, if it's like, even I think join us is okay, but honestly, it comes down to like specifically the framing. And also one other thing that we don't really talk about in this presentation, but I've learned different companies have different risk tolerances. And that is important also to know what your company's risk tolerance is. I've worked with companies that are extremely conservative, and anything that can be seen as remotely illegal hot water, they steer clear from. And some, they're okay with a little bit of risk. They're like, it's worth it, it's not a big deal. So also that's why I like to say, this is all relevant to your individual companies, and that's why I'm like, you got to top tier internal counsel and get the feel for where you are at. Yes.
Not weighing in from a counsel perspective, but for your scenario, it's the difference between your CEO using verbiage that's comparable to you must go, versus it's optional or you shall go, similar with contract language, must and shall. It's two different types of intent. And I would be concerned if he tried to, or if the CEO or other leaders try to bake in attendance into some type of performance scorecard. So if they try to say any ERG or anything that could come across as discriminatory, bake it into a performance scorecard where you are paying your compensation, your employment elevation, or anything tied to your employment is baked into that scorecard based off of attending those events, then that's a problem.
Which brings me to another question. When we do our work plans for the year, and let's say culture is one of the themes, we say as part of that to meet that benchmark, I, as an employee, will extend myself beyond the work to develop a relationship with my colleagues by joining an ERG and being an active participant in the events and activities that we have. That is tied to your review. Have I met the goals that I have set for? So I know you're not a lawyer.
I don't
But that just brought up a really interesting point because we just did our plans.
It depends on how that benchmark is written.
Yeah.
Are you voluntarily adding to the culture, or do you have a requirement that says you have to be X, Y, Z in culture?
Based on how that was worded, I'm not a fan.
So I'd say examine the language around benchmarking and anything and everything related to employee engagement has to be voluntary. Any level of employee engagement.
Similar to that, like less defined about culture, but more like the CEO said, I'm gonna be there, so me and the executives are gonna be there, so if you guys wanna get FaceTime with us, more just like social, would that also probably be?
I think that's been on the safer side, at least even working with those more conservative companies, that's okay. But again, the saying that you have to do this thing. And even then, I've heard from members, oftentimes the ERG leaders aren't the ones who tell me this, but sometimes I speak to members, and sometimes there is like a requirement for people to go to certain social things. ERG leaders, they don't like to tell me that, but apparently it exists. So making sure that there's, even from a team level, that there's no requirement, even if you're on the HR team, even if you're on the DEI team, which you would hope that wouldn't be an issue, but you never know. Next piece, privacy complaints. This is really where it comes down to the data piece that I was just speaking about. There are a lot of data privacy laws that just haven't really been considered in the ERG space, whether it's local data privacy laws, like California has a set of local laws. GDPR, obviously, you think about that when it comes to our folks in the EM. So that's why ultimately, one of the two things I like to say, I sometimes refer to the diversity data as like the identifying data around people in the company, race, age, gender, all the things. That should not be given to ERG leaders, especially when it comes to identifying specific individuals. And something problematic that I've seen in the space is that sometimes HR will even assist ERG leaders by saying, hey, we just had these new people join, and they said that they are a veteran, so you should reach out to them. Again, this is real stuff that's happening, and that's why I have to speak on it. Even if, hypothetically, you are in HR and you have access to that data, you should not be using it in an ERG capacity. I'm speaking in terms of being an ERG leader. If you're an HR ERG leader, you shouldn't be using that data to bring new members in. Basically, one other thing before we continue with the champion here, breach of confidentiality. This can just show up in a number of different ways too, but that's also where I say if someone were to even disclose to you on the settings in which that information comes up again later in the future. Even sometimes that's another problem with having people identify themselves as they join your ERG, which a lot of ERGs require them to do, even though we just talked about that. That has definitely been used occasionally when it comes to employees later suing for discrimination because they've disclosed information about themselves to the ERG. Long story short. So best practices, we talked about this, but even just letting your ERG leaders know what's appropriate versus what's not appropriate. And we're gonna get into some of these things shortly. Disclaimers, that's an important one too. Oh, also I'll just say, something that happened to me last year. I was at a conference where an ERG software was presenting. If you know me, you would know I'm notoriously anti-ERG softwares. I think that we have all the software we need within our organization for free that we're just not maximizing. Nevertheless, ERG software was presenting last year and they were saying, oh, you can always just create a separate space for your members and like some for allies basically. And someone literally stood up during the conference and said, nope, don't do that. We just went through a whole legal thing on this and got sued for it. Also, people have come up to me back to back. I've been doing a version of this presentation since back when I recorded that interview with Tiffany in November. People have come up to me back to back and said, yep, us too. We've dealt with that too. So this is something that is happening, really, and that's why I bring it up here. All right, this one. Like I said, this is what I was telling you to brace yourself for. Which company practice could result in an ERG being classified as an employer-dominated union? The U word that we also typically don't talk about in the ERG space, which is illegal, by the way. So you don't want to be classified as an employer-dominated union. Just to hide something important to consider that a lot of people don't know. Okay, either some people know or you've been listening to me shouting this out on LinkedIn for the past few months. The ERG leaders, if they are referred to as representatives anywhere within your documentation, that should be removed immediately because ERG leaders, they represent themselves. Employees that represent other employees, other bodies of employees, that's what a union does. That's not what ERGs do. And this is coming directly from, I have someone that I met recently, corporations bring them in when unions are forming, essentially. So I'm hearing this from a legal expert in the union space. And really, what they stated clearly, ERG leaders should not be referred to as representatives of their communities. We'll talk about the intermediaries in a second. Which of the following of these new options here could cause an ERG to be classified as an employer-dominated union or labor organization? Same question, new options. Look at us. I like it, which is the correct answer. And this is a tough one for people to hear. And if ERGs are encouraged to advocate for specific policy changes related to workplace conditions, that means if ERGs are championing for inclusive benefits that are relevant to their community, that's what a union does, is champion for benefits. And this is not coming from just me. Like I said, this is coming from people who literally are union experts. Don't worry, you all, we are running a little late from the last session. So you're just catching the tail end of the legal trivia. I think someone might have had a question with me saying that. I just didn't see who had it. Did someone have a question on that?
No, I'm just excited. I was like,
Yes. Yeah. This is a really hot take, by the way, because again, I know that a lot of ERGs actually celebrate the fact that they've championed for some inclusive initiative at their company.
it's interesting because we've seen that in our one of the ERGs, the family one, and we've had people say we should have more benefits for families as some of the things that they think we should. Interesting.
Yeah, that's kind of part of the issue with the space right now, is that this has been pushed. And actually, if you notice some ERG models championing for inclusive benefits, I think that's nested under culture probably, I don't know. You should not be doing that. Which, to mention earlier, if ERG leaders shouldn't serve as representatives of their community, but they can go and as individuals say, hey, I would love to see this benefit included. ERG leaders and members are encouraged to do that on an individual basis. But ERG leaders should not be going to the company on behalf of their members to say, we need X, Y, and Z, because that is what labor unions do. We're almost done, so we're almost out of it. All right, we talked about this a little bit earlier, but why should ERGs not be positioned as employee representatives, ERG leaders? Okay, awesome. Almost always with a question like this, all the above is the answer. So it looks like we're on the same page here. We talked about it before. ERG should not formally advocate for workplace changes. I hate to be that person in a space full of people who say ERGs, one of their best perks is that they do advocate for workplace changes, but that is not what they should be doing. And if you were part of our session yesterday, I gave you all basically a phrase that you can use to describe what your ERG program is, one that is very different from what we hear right now in the space. ERGs scale employee engagement initiatives through niche programming. That's what they do. I would love for companies to stop speaking about ERGs explicitly and only as DEI initiatives, because they are really, more than anything, employee engagement initiatives for niche groups of people. Now there is potentially a way that we can work with DEI. That gets a little bit into touchy areas too. But nevertheless, if you frame it through that, you're really saying that we are using community marketing to drive the internal brand of our company. That's what ERGs are doing. So just putting it out there. All right, 3 more questions. Almost there. We talked about this already, but if an ERG wants to push for paid parental leave, what's the best way to do this while avoiding legal risk? I already gave you all the answers, so I feel like we got this one here. Good stuff. I like it. Individually, you can go to HR and do that. This is not a collective body for change. Also, even then, realistically, you could see how that could pose a threat to a company when the power of the employees becomes more powerful than the company itself, which is why really, and I get we might want change, but the ERGs is just not the medium for that. That's really what I'm trying to tell you all. For the few spaces where ERGs have been eliminated, it's really because the body of employees was a threat to the organization. When it gets to that point, that is when it's like, we might as well just shut this down. And ERGs do so much good. That community is so powerful. I think it's highly underrated right now in the ERG space, but that alone is enough. The learning and development aspect of ERGs, that's enough. Even the volunteerism and give back, that is enough without us having to also add in these extra things that could potentially jeopardize the program. All right, last 2 questions. Why should ERGs avoid negotiating back and forth with company leadership over workplace changes? And you see all the above, it's almost always the answer. So even with this, why ERG should avoid it? 1, you don't want to be positioning your ERG similar to a union. You don't want your ERG leaders to be framed as representatives of their employees that they're representing. Which also, like I said, when your ERG is an employer-dominated union, when your ERG program is that, it's also illegal. So there's some major NLRA violations. And just to say, NLRA stands for the National Labor Relations, actually NLRB, National Labor Relations Board. But if you want to know what I'm referencing, you can look it up right now. NLRA Section 8A2, where it talks about employer-dominated unions. When I found this out, it was just mind-blowing to me because I said, wow, most companies right now are operating their ERG program as an employer-dominated union, which was concerning. So that's why you also want these things stated explicitly, like I said, what your ERG program is not. This way you're not in potential violation of the law. Last question, a disability ERG, true or false, can submit a proposal requesting expanded benefits as long as it aligns with the DEI strategy. Hey, I'm so proud of us. We got this right. But it's actually, I get it's not exciting news, but in all reality, that is why I am deeply concerned with the ERG space right now. But because ERGs are nested under DEI, a lot of the times inherently that means that the DEI team is trying to leverage the ERGs as a tool to expedite things or get them done. But in reality, that is out of scope for the program. And again, putting your ERG program in some legal hot water. And that's really just not the responsibility of ERG leaders anyway, who oftentimes get into the space more so just around the community, the learning and development piece. So it's oftentimes just an added extra burden. Again, just to reference what I'm talking about, employer-dominated union, an employer organization that an employer controls, influences, or interferes with, particularly when it comes to workplace conditions, wages, or grievances. Again, NLRA Section 8A2. You will see it stated there explicitly. And this is more than just an ERG thing. That also means that if you have a culture council or even like a safety council at your organization, they should not be championing for more inclusive benefits, because that's what a union does. And it's important, I think, that we just don't talk about it enough, our proximity to unions. Concerning, actually. Again, I can not saying it's right, but I see why ERGs have been shut down in some cases, because again, a union makes it a us versus them type of dynamic, and the company can just say, let's remove them. There's a lot of things that need work in the ERG space, is what I will say, so that we are not positioning ourselves as employer-dominated unions. All right? Like I said, I hate to be like the doom and gloom person here. Join the ERG Movement newsletter, and we talk about it more. That's not just doom and gloom. Yesterday we talked more about membership growth and happy things like that too. But I do, like I said, I go by the ERG homegirl, so I vow to keep it real with you in the ERG space, even when others do not. I see 2 questions, and then we will move right along into the allyship piece. Thing number 1, how do you expect the executive orders from the new administration to impact ERGs going forward? My answer on this is still the same. Logically, I'll give you my logical answer to this. For me, right now, the executive orders at large are related to DEI, oftentimes not ERGs, and more specifically, not to employee engagement in particular, which is also why I'm saying it helps to position your ERGs under employee engagement, or even if they are just inherently under DEI because there's no capacity from the employee engagement team, just making sure that you're talking about them as employee engagement initiatives. Even that language that I said, scaling employee engagement through community marketing. Speaking about that via employee engagement helps to protect your ERG program ultimately, because no one's attacking employee engagement. I think it's commonsensical for folks to understand if people love the company more, that they're going to stay. In the same way that in the marketing space, which again, I believe if you run an ERG program like a business, it helps for it to be more efficient, and this is one of the ways that it shows up. Even within the marketing space, they don't just promote things to everybody. Oftentimes they have segmented groups of people that they'll target their messaging towards. Those cohorts, that like niche cohort marketing is a well-known practice in the marketing space. No one's attacking that. In the same way, this is just internal marketing. We're helping people, our employees, to love our brand, our company more with these niche communities. And no one, whenever I say that to even the most conservative of CEOs, they get that. They don't fight that. But when we do add in, they're scaling DEI and pushing for inclusive policy, it sets off some flags in some folks' heads. And again, that's why one of the reasons I would say at the federal level, and also there's technically only 2 other places now, but realistically the only one worth mentioning is at the federal level and at Twitter, now known as X. Those are the only 2 places where ERGs were just eradicated with, important note, new leadership. New people came into the space who had a completely different strategy for the space that they were coming into. And they said, wow, the body of employees is a threat to me. So let's just remove community, and that's been done historically all the times when people take over a space, to remove people's ability to connect and to communicate, because then it serves as a threat. That's the only reason why I would say ERGs are in jeopardy, is if the company is maybe having a new strategy that is in direct conflict with how most employees view the company. That's what I would say. Also, in general, Elon Musk, he has a different view on work and humans than most companies do, which is also why I'm not concerned. Literally, when he took over Twitter, he told the employees, like, hey, this is going to be the hardest you've ever worked in your life. You're going to work the longest hours. He cut not just ERGs, and they had an amazing ERG program, but even the benefits were cut. Some employees had to take tissue to the workplace because they did not have enough. Like, things were cut at large because he was just like, I just have a big dream and I want to get the work done, and I'm cool with treating humans like robots. And even now, we can see how that shows up in the federal space too, But again, that's just their take. That's how they want to run their entity. And there are, believe it or not, some people who are okay with that, who are okay with chasing the big dream so much that benefits don't matter to them. And for them, I would say that those companies are for them. But most companies actually do understand the common sense part of treat employees and they'll like you back and they'll say and all the things. All right, last question. Is there anything legally wrong with each ERG at a company not having a defined budget and for them to all share the same pot of money? Part A to the question, I'm not a lawyer. So I always like to just say that. But part B to that question, I would say it would be problematic if some groups were to take most of that budget and some groups didn't really have access to as much budget and things like that. I could see how we talked about in the session, this disparate impact and disparate treatment, those claims might come up because there's not equality when it comes to how the budget is split up. So I could see that coming up. Now, I will say most of the time, ERGs and ERG leaders aren't the ones making these claims. So again, low risk, but if your company is completely anti-risk, then just something to know.